What is alternative dispute resolution, or ADR? What it is, it's a three-step process which starts off with negotiation, goes to mediation, and then goes to arbitration. Negotiation is simply negotiating with your counterpart, trying to come up with something which, careful of these words, which you and your counterpart will invent. You'll collaborate and you'll come up with a solution that no judge or arbitrator is going to think of, because you're in it. You're both in it. You know what works for you. You can trade ideas and you can get very innovative. That doesn't work. You're required to go to the next step, which is mediation. And mediation is, in fact, the same as negotiation, except that you have a mediator helping both parties to negotiate. It's assisted negotiation. So the mediator is qualified and skilled to look at what the underlying issues are, what the underlying interests are, to take all the rights and the power away from the conversation. That's what a mediator does. But the bottom line on mediation is that it's only the parties that can make an agreement. The mediator can't tell them what to do. If they make an agreement, that agreement will guaranteed be something quite creative. It'll be customized, bespoke agreement for these two parties, and you can't get better than that. If that doesn't work, then you're getting into a situation which is required, called arbitration. Arbitration is very much like a court case, but it gets rid of all the shenanigans that go with litigation, all of the tricks, all of the pleadings, all of the frustrations, the time waiting to get a court date, having absolutely no idea what the outcome could be, because courts can be very erratic. So you're bringing in an arbitrator. You'll sit down. If the arbitration agreement has been written properly, and I have to underscore that, then the arbitrator will behave and do what a judge does by listening to each party, a little bit of cross-questioning. You may have your lawyer there, you may not, but an arbitrator will not allow really stupid things to go on just to delay the process. So the promise of arbitration, if it's done properly, is that it's faster, it should be cheaper, although it isn't always. And if you take that package, ADR, alternative dispute resolution, you're in a situation that is much better than leaving things unagreed, which means I'm not going to enter into an agreement for a dispute resolution process with you, because why should we do that? We're not going to have a dispute. Well, when the day comes that there is a dispute, and there are always disputes, then one of the parties will usually call the lawyer. A lawyer's letter will go out, next one will come in, and you're on a merry-go-round for 4 years possibly. So the important part of this is that if you want to get a good agreement for you and your counterpart, you're interested in all sorts of things. It may be continued relationships, it may be profitable agreements. It's not going to happen if you start fighting in court. If you're able to either get creative between the two of you to collaborate and come up with something that works, or you're able to get a mediator to help you do that, you're way ahead of the game.